Okay.
So Nick McGregor, criminal defense attorney, Nashville.
Yes. Hello. Thank you for having me.
Perfect. Only attorney I know who's tried more cases than me.
I don't. You say that. I don't know that that's still true. You had a lot recently, but
I hit 50 this week, but I'm pretty sure you've got close to 60.
Maybe. I used to do so many, and I don't do as many as I used to. I'm willing to, but so you may have passed me, but I did. I will say it's been years since it was 30, and I stopped counting at 30.
Yeah, well, and I think being willing to and having tried so many is probably one of the reasons you don't have to anymore.
I would agree with that. I would agree with that, actually.
How much do you think the district attorney takes into account, we can't threaten this guy with trial, he's going to actually try it, and he can win it?
I think it may be a combination of a couple of things. In terms of and I heard that from the very beginning. People would say, older attorneys would say, once you start having trials, your offers will get better. Mm-hmm. And nobody gave me the reason why. They just say that's once you start having trials, your offers will get better. I think a bigger reason is I can identify issues that'll be an issue for both me and the prosecutor at trial. Mm-hmm. So if you haven't had a trial, you would then say, well, I think I know how it'll go, and it'll go this way. But once you've had a trial, you can say, well, I think this piece of evidence is actually going to be very, very impactful to a jury in our favor or against us. And I could sit down with a client and say, look, I've done 100 of these. And the moment that they hear you pulled the gun out, I'm telling you, we're going to lose them. I've seen it. Mm-hmm. Or you can go to a district attorney and say, look, you and I both know we've had plenty of trials.
Sure.
The moment they hear that your alleged victim pulled his gun out, you're going to lose these people on premeditation, or you're going to lose these people on blank. And so I wouldn't say that it's the DA is so afraid of me. It's just the conversations of, let's be realistic about how things are going to go at trial, both with the prosecutor and my client. I can predict so much better what is going to happen, and I can know, if you're the prosecutor, do I need to start pushing you on, no, we need a better offer, or you need to dismiss this because this evidence is going to play like this at trial? Or do I sit down with the client and say, look, this is why you hired me, because I know that the jury is going to really struggle with your version of this story. Mm-hmm. And I'm telling you, when that happens, your sentence is going to double, and we need to discuss not going to trial. So I wouldn't say necessarily that anybody's afraid of me. It's just the ability to predict how it'll go and move accordingly really comes around. But you're right, though, in terms of what I believe to be true. No prosecutor's ever told me this, but I think if I were a prosecutor and I looked at you and I said, Nathan is somebody who will make his client take a deal before he'll come and fight me over it, I may offer a little bit worse. Or if I'm like, Nathan's the guy who's going to waste my entire week, or I can just make it a 3-year sentence instead of a 6.
Sure.
That's somebody, and or Nathan's somebody who's going to waste my entire week and might win. I'll give it. That would be my mentality. I've never prosecuted a case, so I don't know, but that would be my mentality.
How many trials do you think you had to have before they started viewing you different?
A couple. It was more than one.
Yeah.
It was because my first 2 or 3 were not necessarily something where I thought I was being viewed different. Yeah. My first one ever was an arson, where in the police car, the guy says, yeah, I burnt their stuff, and so that was difficult. I was naive enough to think that I could still acquit him.
Sure.
And so because I had found some kind of not congruent story on the confession, which the jury was out for 45 minutes and they convicted him.
Not a good sign. Yeah.
Only to learn that the prosecutor had barely looked at the case, read the summary that said the guy confessed, and walked right in and did it. But I'll tell you this, though, and the guy was actually very happy with how much effort I put in. I put in a ton of effort for it. And I'll say my big takeaway from that trial was that juries don't know how hard it is to find somebody guilty, and they don't know how hard it is for the state to actually meet its burden, and they're not presuming people to be innocent unless you help them understand what all that means. Because if you, like, I look back at it, and like I said, they were out for 45 minutes, and you had one police officer saying he confessed in the car, another police officer saying that he confessed outside the car. And those are different stories. Now, both of them saying he confessed, and perhaps the jury reconciled that and said, well, I don't care where it was, he confessed. But I don't know that they even had that conversation, because I don't know that they realized that they needed to. And that was when I started changing how I address the jury.
Sure.
And I don't have any tricks to, like, I'm not trying to trick anybody or corner anybody. I just want jurors to know, and this is any advice that I'd give to an attorney and a juror. I want them to know what the presumption of innocence means. I want them to know what beyond reasonable doubt means and whose job it is to prove it beyond reasonable doubt.
Yeah, and I actually remember probably 9 years ago watching one of your trials, and I stole something from you that I've literally used ever since. Because the common phrase is innocent until proven guilty. And you hit that jury and you hammered it home, it's innocent unless.
That's right.
And that framing I have put into every voir dire for 9 years. I mean, that's probably been 40-something of my jury trials. And it was such a great, let's restructure this. Let's get the jury. But it wasn't just the term, the phrase. It's that idea that you were putting forward and getting the jury to understand why we're here and what this really looks like.
I always start with that, too, because in terms of, I never want to trap anybody into like committing to the evidence or think that I'm playing dirty pool, because I think if I can get the jurors to understand the rules of the game, then when I go play it, I'll be on a much more level playing field. And so the common phrase is innocent until proven guilty, but when you think about that, inherently that means you're only innocent right now, and that's going to change.
Exactly.
Where innocent unless proven guilty requires something to happen for you to become guilty. And that is a really tough thing for jurors. Like, they say that the jurors struggle with two things, beyond reasonable doubt and that presumption of innocence.
Yeah.
And they are woven in together like that. And so, because I mean, think about, and I'm rooting for the defendant, right?
Of course.
But when I get a call from somebody who says, hey, my boyfriend's been arrested, I don't think to myself, oh my goodness, they're probably wrongfully accused. I'm like, well, what'd he do? And so I do not want to be critical of any juror or any person who thinks because someone's on trial that they might have done something, because that's such a natural feeling.
Yeah.
However, you have to give this person a fair trial. And if you're thinking they're here, if you're on the fence about innocent or guilt and you're letting the fact that they're on trial or that they've been charged push you to guilty, then you're getting it wrong. And you've got to talk to the people about that. But you can bring up example after example. I mean, one that I bring up with jurors is just how many people think, he must have done something, or he wouldn't be here. And it's everybody does. Even the people who don't want to admit it are thinking, how'd you get on trial for murder? You didn't do anything. But not one person, and I bring this up to a lot of jurors, is not one person walks in and says, oh my goodness, that guy's wrongfully accused. And so you really have to undo that. And I thought that I didn't do enough of that in my first trial, and that I didn't do enough of beyond reasonable doubt and whose role it is. And not everybody realizes, like jurors, and I would say this to attorneys too, not everybody realizes it's not a back and forth contest of who has the most evidence or the most witnesses. It's really not our job or responsibility to prove anything. It's not our job to call the witnesses. It's our job to call into question the evidence that they say they have. And you really want to make sure you know that, because you never want it to be that, and you hate it because you put so much time into preparing and so much effort into trying to save someone from a conviction, that you don't want a juror to not follow the rules or not be following what the law says that applies to trials. Yeah. And so you want to go through that idea of look, prosecutor's job to put on all these witnesses, call witnesses. It's my job to ask them the questions, and to make sense of what they're saying and as to why it is not somebody who you should find guilty. And once you can kind of get that idea, because you never want it to be like, they put on 10 witnesses, he put on 1, or he put on 0. You know, they had no evidence he didn't do it. No, I don't put on evidence. And it was very early on, I think it was maybe in my second trial, which was bad facts. The guy was on video confessing to it. But somebody had asked me, a juror had asked me later, like, why didn't you go see if you could get surveillance video showing, like, where these people were prior? And I thought to myself, I'm like, well, you should have known that evidence is not what I'm supposed to do. I question evidence. Okay, so mental note. I know now that I need to address those things.
How much, if you look back on all the trials you ever won, all your acquittals, any of your not guilties, how much of it do you think turned on jury selection as opposed to the facts?
I don't think there's any acquittal, maybe not even any conviction, that is so heavy on jury selection that you can ignore the rest.
Sure, of course, but
I think that it's almost like a video game in which the very first level, you can't beat the game if you don't beat the first level. And the first level is making sure the jurors know how the law will apply to jury trials. Innocent until proven guilty, the beyond reasonable doubt, the roles of the attorneys, the mentality that because this person is here should not influence you towards guilty. And if you can get from that level to the next one, if you can't get from that level to the next one, you're going to struggle with the rest.
Sure.
If you can, you'll then get to opening statements. Opening statement, even if you deliver the best opening statement ever, you have not, whether you're the prosecutor, convicted somebody, or the defense attorney, acquitted somebody. You've got to then deliver on the evidence. Questioning, for us, it'll be questioning the evidence. And if you deliver the most eloquent and beautiful opening statement to where after your opening statement, everybody would vote not guilty, but then when it comes time for, if you deliver the most eloquent and beautiful opening statement, and everybody is ready to vote not guilty at the conclusion of your opening statement, but then when it comes time for the evidence and you're just unable to question somebody so that what you're saying happened actually comes out of the witness's mouth, they're going to forget your opening statement by the time it is to vote guilty or not guilty. So you have to get to that next level of, in the proof stage, the testimony stage, the evidence stage, can I show that there are enough problems with the state's case that this person should be found not guilty, or that they didn't do it, or whatever it may be. And then, even if you get through that stage, you're, as an attorney, so invested in the case that you hung on every word. To think that a juror hasn't spaced out for a moment is naive. So even if you've gotten all the way there, giving the closing argument and reminding them, you did hear 2 witnesses say, red t-shirt. Video surveillance showed Mr. Defendant in blue. And having to remind them the significance of these pieces of evidence, that identity is an essential element in a case. So I'm reminding them that these pieces of evidence that show that there are doubts and questions, and those are based in reason, is another stage to it. And so I almost treat it like a video game of levels, where you're not beating the game if you don't beat every level.
You've got a bunch of trial experience, but you actually recently won a really good appellate opinion, didn't you?
I did. It was, I guess it was, I'll just start that over. I did. It was about a probation violation. I've had a couple results be decent with appeals that I've worked on. Appeals are very difficult. So this case in particular came right after another piece of law. There's in Tennessee, when you violate your probation or you're alleged to have violated your probation, the hearing is required to have one, did you violate, and a separate, if you did, what should happen to you, whether it be serve all of your sentence, part of your sentence, none of your sentence. And so prior to that, it was very easy to just mix those two things together. All right, well, it sounds like you violated, but let me just see what we can do. And in this particular case, I made sure that they had to separate those two things. And the state's proof was lacking that the defendant actually violated.
Sure.
And so when the judge determined that the defendant violated his probation, we appealed it, and the appellate court sent it back and said, we did not hear that the defendant violated. You now have to have a rehearing. And at the rehearing, able to show that the defendant had not violated, and we didn't even get to the punishment phase. And so he had received what's called expungible probation, which is why it was such a big deal. And at the first hearing, it had been revoked, but the appellate court, deeming that he did not, that the state did not meet its burden by showing evidence that he violated, they sent it back. And then at the rehearing, we were able to show that the evidence wasn't sufficient for a violation, and he kept that ability to expunge it. So, but appeals are very difficult. I tell everybody who calls for an appeal that they're very difficult. And I say that to anybody listening. If you're an attorney and you think appeals are easy, then either good on you or you're not doing them right.
Yeah.
And to anybody who is looking to have a case appealed, the truth is that they are very difficult, and they're very difficult to win. And the reason that is because in Tennessee, the appellate court starts with the idea that the trial court got it right.
Yeah.
And only if something is egregious enough to where they just cannot uphold that decision will they change it. They may find things wrong. They may say this shouldn't have happened.
Harmless error.
But if they determine that the error was harmless, which means that what happened down there that you're grieving about would not, in their opinion, change the outcome, they'll still deny you, even if they say you were right for your arguments. And here's something that I'll say, too, and this goes to any jurors and lawyers. The appellate court in Tennessee, they have decided that jurors get it right. And they will start with that notion. Credibility of witnesses, they say that the jury is the people who decide that. And I say that because if you hear about cases, one of the famous ones was in South Africa, Oscar Pistorius, where guilty, then not guilty, then not guilty, then guilty. And so many courts reviewed it brand new. Where in Tennessee, they don't start it over. So if you're on a jury and you're thinking, oh, someone else will fix this if I get it wrong, that's not true. Yeah. They give so much deference to jurors that they will not fix it if you got it wrong. And that's something that, like, I make sure that I tell jurors, please don't think a higher court's gonna change it. Yeah. What happens with appeals for jury trials is in the event that the jury heard a piece of evidence that they should not have, and that evidence was so significant that a different jury may have reached a different outcome, that is when you will get relief.
Sure.
Otherwise, they're gonna just assume the jury got it right.
Yeah.
And so if you're on a jury, you have to get it right.
It's interesting because when you look at all the statistics for cases that have been overturned, cases that have been sent back, or where the Innocence Project has cleared people or DNA has cleared people, the one thing every one of them had in common was a jury convicted them.
That's right. That's right.
And it's crazy to think, because in every trial, kind of the same framework's occurring, the defense attorney saying not guilty, the state saying guilty.
Yep.
And only the jury is really pure. They're the only ones who really kind of are the true scales in the system.
And they're the only people who are absolutely fresh and brand new to the case. The judge, although he or she may not have a strong opinion, has often heard a little bit about the case.
Yeah.
The jury is the only group who knows nothing and comes in and listens.
I think they're kind of the real saving grace of our system when they do their job right. Though, as you pointed out, the only way they will do their job right is if we do our job
right. And that's right. And that's it. It's not fair to criticize a jury for getting something wrong if they didn't know the rules.
Correct.
So and that's why I would say to anybody who's getting ready to have a trial, put so much emphasis on just explaining beyond reasonable doubt and and innocent until proven guilty. Because even if you don't ask anything personal to these jurors, even if you learn nothing about them, if they seem to be people who are willing to listen and they understand that, you'll be able to perform your trial in the manner necessary to get your best shot.
All right. Well, Nick, I really appreciate you coming by. Thank you so much for being here.
Having me.
Catch up with you later.